Well, the title they gave to my talk was What California Once Knew. I'll change that just a little bit. What Californians once knew. Back before California was even a state. Here's a case, Baker versus Baker, 1859. The first purpose of matrimony by the laws of nature and of society is procreation. A century later, a case called DeBerg versus DeBerg. Marriage serves the public interest because it channels biological drives that might otherwise become socially destructive, and it ensures the care and education of children in a stable environment. I mean, you got to step back and ask, why is it that society gets involved in the marriage relationship at all? I mean, it could just be like any other contractual relationship where the only role of society is to enforce the terms of the contract. But long ago, not just in this country, but throughout all of human history, society realized that it was a third party in that relationship because of the significant societal interests that arise from it. On the eve of the California Proposition 8 revolution, here's another case in California, in remarriage versus Ramirez. The sexual, procreative, and child-rearing aspects of marriage go to the very essence of the marriage relation. What Californians once knew. That all started to change as Hawaii started toying with the idea of same-sex marriage. In 1994, the state legislature decided to change its law to require the state recognize marriages performed in other states as a matter of public policy. The people of California said, whoa, and in 2000 they adopted Proposition 22, said not here, no. Unfortunately, it was only a statutory initiative. It reversed the legislature's view, but it didn't lock it into the state constitution. A few years after Proposition 22 passed, a mayor from the city of San Francisco, whose name you might recognize, Gavin Newsom, started issuing marriage certificates in violation of this people-adopted initiative, Proposition 22. The California Supreme Court rebuffed him, said, you don't have authority to say that Proposition 22 is unconstitutional. Only we get to do that, and invalidated what he was doing. That was a case called Lockyer versus San Francisco in August of 2004. But shortly thereafter, as an initiative was being circulated to be put on the ballot in 2008, the California Supreme Court said under the state constitution, Proposition 22 is unconstitutional. And they refused to issue a stay of that decision pending the outcome of the people's decision forthcoming in the following November, so that after the people adopted Proposition 8 in that November, they could say the people have revoked something, a long-standing right that didn't exist until the prior May. The vote to approve Proposition 22 was about 65 to 35%. The vote to approve Proposition 8 had declined. It was only 52.24 to 47.76%, a difference of about 600,000 votes. It was challenged, this constitutional amendment adopted by the people of California was challenged as an unconstitutional constitutional amendment. Now think about that for a moment. If we talk about distortions in our law, thankfully, in May of 2009, the California Supreme Court upheld the people's decision of the state in Proposition 8, even though the Attorney General of the state at the time, former and then future Governor Jerry Brown, refused to defend it. The same parties then brought a federal legal challenge, Perry versus Schwarzenegger. That landed before Vaughn Walker in San Francisco. And in August of 2010, he ruled that it was a violation of the federal Constitution. Now, mind you, at the time, the controlling Supreme Court precedent was a case called Baker versus Nelson in 1972, in which the Supreme Court denied even to take up an appeal of a same-sex marriage claim in violation of equal protection, dismissed it for lack of any substantial federal question. That was controlling Supreme Court precedent. Von Walker decided he wasn't bound by that. Again, the Attorney General of the state, Brown, refused to appeal that. So the proponents of the initiative intervened and sought to appeal. The California Supreme Court certified a question saying they have standing as the proponents of initiative under our state's law. Judge Reinhardt on the Ninth Circuit was more than happy to get that decision because it allowed him to write a very important decision affirming Judge Von Walker's decision. That then went to the Supreme Court, and in June of 2013, contrary to California's interpretation of its own state constitution, it held that the proponents of the initiative had no standing. The Supreme Court a century earlier had described marriage this way. It is the union for life, one issue, of one man and one woman as the sure foundation of all that is stable and noble in our civilization. Loving versus Virginia, the case striking down Virginia's anti-miscegenation law, said was explicitly related to the unique procreative capacity of opposite-sex unions, an issue that was made skin color irrelevant to the purpose of marriage. And the issue was whether same-sex marriage was not similarly situated because that fundamental right, as it had been defined throughout all of history, was tied to that procreative function, that complementarity of the sexes, something that was fundamentally and necessary to our very existence. And that's why Loving came out the way it did and why Obergefell should not have. It didn't matter. I'll just give a little back further in history because I'm a big fan of Henri de Bracton, 13th century. Here's what he said: from the jus gentium, the law of nations, comes the union of man and woman entered into by the mutual consent of both, which is called marriage, and also the procreation and rearing of children. Tied to the law of nations, the law of nature. Blackstone, relationship of husband and wife is founded in nature, directing man to continue and multiply the species, parent and child, consequential to that of marriage. I mean, you can go on and on and on. Von Walker found otherwise. He said, marriage is only the state recognition of any couple's choice to live together, to remain committed and to form a household based on their own feelings and to join in an economic partnership. In other words, we've destroyed the very reason society had an interest in the institution in the first place. He denied, stunningly, that procreation had been any part of the historical purpose of marriage. The ruling introduced, as one newspaper said, an implicit revolt against the institution into its very core. It continued the deinstitutionalization of marriage that began back when no-fault divorce came to us in the 1960s out of California, destroying the permanence feature of marriage and the interests of society in that. This compares to, say, the liberalization of the abortion laws back in 1960s, also in California. After a few years, they realized that that pendulum had swung too far and ignored the other half of the rights were at issue. And that debate was going on. How do we reconcile these two interests? The interests of same-sex attracted individuals to stability in their own relationships and the interests of children that has been so described. It was that shutdown of that debate that Roe versus Wade gave us and locked things into perpetual political animosity in this country for 50 years since. I think the same thing is happening with Obergefell. There was a debate going on how to accommodate the competing interests, the necessity of family, the connection with children and procreation versus the interests of those same-sex attracted to have their relationships protected in things like hospital visitation and other rights. That debate was occurring in this country, and Obergefell shut it down just as Roe had shut down the debate over abortion. We would have come to some accommodation. Eventually, the American people are a generous and charitable people. But what the court did is take an unenumerated right under substantive due process. Previously, the courts had looked at whether the asserted right had been part of our history and traditions. And nobody can plausibly make the argument that this was the case with this claim before the Supreme Court in Obergefell. So the court defined the right at such a high level of generality as to make the inquiry meaningless. It was a point quickly pressed by others. Within a year of Obergefell, claims for polygamy recognition were brought in Montana and Utah and elsewhere. They were defeated, but the claims were there, and they had great viability under Obergefell, it seems to me. The claims by polyamorous or thruples, I didn't know at the time that was even a word, but it is apparently. They fared better. There's a case out of California. A thruple won a suit to extend the rent-controlled lease that they were under, arguing that Obergefell said they had a right to be treated as a family, despite this. There was another gentleman, I couldn't recover the article, who claimed that his relationship with his horse was such that marriage should be recognized in Kentucky. These things result directly from the Supreme Court's decision to give such a high level of generality to the question of, was there, recognized in our history and traditions, a fundamental right here? Which brings me back to Obergefell, and now the claim of religious liberty. Kennedy acknowledged explicitly that the traditional view of marriage has been held and continues to be held in good faith by reasonable and sincere people, and that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. This is Kennedy's language in the Obergefell decision. Tell that to Jack Phillips, who's been under assault for a decade for his running of his Masterpiece Cake Shop case. Tell that to the website designers in 303 Creative, or Bush versus Nib. Although they won their cases on free speech and religious grounds, they spent a decade defending this, racking up costs. And tell that to Kim Davis, whose case is now pending back before the Supreme Court. Kim Davis was, of course, the county clerk in Kentucky who said, I can't do this consistent with my religious faith, to authorize and sign off on a marriage certificate that recognizes something that is contrary to my fundamental faith. She didn't say, I'm not giving same-sex marriage licenses. She said, I'm going to take a pause of giving any marriage licenses until the governor of Kentucky can give me an accommodation to let me remove my name from sanctioning that relationship. She was hauled before the court. She was jailed. She was bankrupted with hundreds of thousands of dollars in damages for the emotional distress she caused by this. Her case now is up before the Supreme Court pending on a cert petition. And, you know, we've got a couple of very important things, and the court has changed. Justice Roberts' dissent in Obergefell, it's an act of will, not legal judgment. The right it announces has no basis in the Constitution or this court's precedent. Justice Thomas, in the first round of Kim Davis's case up there, denied cert, but he wrote separately, the court read a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text. By choosing to privilege a novel constitutional right over the religious liberty interests explicitly protected and undemocratic method to do it created a problem that only this court can solve. So he was inviting the court to take this up and revisit it. And then, of course, you get Dobbs, which says it was wrong when it was decided, Roe, and it was wrong now, and we're finally going to correct that error. And Justice Thomas, writing separately, speaks of the potentially ruinous consequences for religious liberty that comes out of Obergefell, and he invites this. All of that proved to be true for Kim Davis. The Supreme Court apparently is taking it seriously because uncharacteristically, rarely, they called for a response to the cert petition after the respondents had declined to file a motion. What we have here, and we should be very clear in the Kim Davis case, this wasn't about the couple being able to get a marriage certificate under the auspices of Obergefell. They got one. It was getting it from her despite her religious objection. It was a Orwellian bend-the-knee move. And I'm reminded, and I'll close with this, Winston Smith, tortured by O'Brien from the Ministry of Love, until he was compelled to not only speak the lie that 2 + 2 = 5, but to come to believe the lie. I'll close with a note of hope. The Sept petition calls on Obergefell to be overruled, not just to carve out a religious exemption. Supreme Court called for a response, as I said. But more importantly, I think the culture is changing. And I got a meme in the email the other day. It was Nancy Pelosi buying stock in baby goods stock futures because of Taylor Swift's engagement to Travis Kelce. Maybe marriage is going to make a comeback, after all. Thanks so much.